Yeah, now we're going to look at Stenberg v. Carhart. This is a 5-4 decision which Justice Breyer writes the opinion, who at the time in year 2000 is a new Clinton appointee, or at least the newest Clinton appointee. And it has to deal with restrictions on partial birth abortions, and with regards to which procedures were actually criminalized and how they were criminalized. And they basically ruled that the ban on partial birth abortions, a particular type in this case, was unconstitutional. So the majority in the case is Justice Breyer, Justice Stevens, Justice Souter, Justice Ginsburg, and Justice O'Connor were all in the majority. Justice Kennedy, who kind of switches back and forth in these cases, is back on the anti-abortion side where he was in Weber. And understand that we say he switched back because in Casey in 1992, he was on the side that upheld or that struck down some abortion restrictions. So in this particular case, the state of Nebraska had made it a felony crime to engage in a partial birth abortion except to save the woman's life. And in addition to the felony, the doctor who had performed the abortion would automatically lose his license to practice medicine. The law was exceedingly specific in deciding what exactly a partial birth abortion was. Indeed, both the law, and in particular the decision by the United States Supreme Court, discussed the specifics of this and other procedures in sort of in exceedingly graphic terms. So the part of this procedure and the reason for the graphicness is because the decision kind of based on two different types of abortions, one known as a D&E and the other known as a D&X. The law was written in such a way that perhaps both of them would be covered under the law, even though one of them, the D&X, was designed to be covered by the ban. So the D&E was not supposed to be covered by the ban, but it was written in such a way that it might be included, and the D&X was what was supposed to be prohibited. So to put that in sort of in simplest terms, a doctor may or may not have been sure the type of procedure was banned and thus might not perform an abortion that would have otherwise been legal. Or a doctor could have performed a type of abortion that he thought was legal only to find out that he was subject to criminal penalty, he or her was subject to criminal penalties and the loss of their license. And thus the Supreme Court finds that the law is unconstitutional for all of those reasons, but also because it placed an undue burden on the woman in her attempt to attain an abortion of a non-viable fetus. So remember, this undue burden standard harkens back. And so this undue burden standard is really a development of Justice O'Connor, which is not shocking as she's in the majority opinion of this case. So, and additionally, the Supreme Court weighs in and says that, well, both under Roe and Casey, once the fetus is viable, the state absolutely has an interest in both the life and health of the woman and the child once the fetus is viable. But this law only provided that the life of the woman was protected, not her health. And because the law had no exceptions at all for the health of the mother, it was also unconstitutional in that regard. So Justice Kennedy does dissent. Justice Kennedy dissents saying that in Casey, he had made clear that the state has strong interest in promoting the potential life, which was to be a balancing against the woman's interest in obtaining abortions. He says that that balancing simply isn't in existence in this case. He writes that the court's decision today, in my submission, repudiates this understanding by invalidating a statute advancing critical state interests, even though the law denies no woman the right to choose an abortion and places no undue burden upon that right. The legislation is well within the state's competence to enact. And he's arguing this because it did not ban all types of partial birth abortion. It banned simply one type of partial birth abortion, at least as worded. So his argument is that there wasn't an undue burden placed, as it was a very limited ban, though the majority says that ban wasn't nearly as limited as Kennedy argues. Justice Thomas writes a dissent, but his dissent is very far beyond where Kennedy's was. Justice Thomas says that Roe v. Wade was, quote, grievously wrong. Although a state may permit an abortion, nothing in the Constitution dictates that a state must do so. So while Kennedy's dissent is that this does not prove an undue burden, Thomas's dissent is that Roe v. Wade is wrongly decided. So you can see sort of the spectrum upon which they're ideologically sitting in. And it's important to note, Justice Rehnquist and Justice Scalia also dissent in this case, though I'm not going to go into too much depth of their dissents. So in the intervening period between Stenberg and the next case we'll do, Gonzalez v. Carhart, Congress passes what is known as the Partial Birth Abortion Ban Act of 2003, which was signed into law by President Bush. And important to note that President Clinton had previously vetoed this bill when he was president. The law, as read, it seems that it would be unconstitutional based on Stenberg, in particular because it only allows abortion to protect a woman's life and has absolutely nothing to do with her health. And so the next case that we do, Gonzalez v. Carhart, is actually going to decide the constitutionality of the Partial Birth Abortion Ban Act of 2003.